Hello, viewers. Welcome back to the platform of Rational Approach. Here in this video, we are going to learn about what is Actus Reus and the four elements of Actus Reus in a rational way. The part 1 has covered the general principles of criminal liability, the foundational basic building blocks of criminal law. In this, we are going to learn about Actus Reus and elements of it. Firstly, what is Actus Reus? Actus Reus has been derived from the Latin phrase. And what does that mean? This means a guilty act. As a law student, as a law graduate, you must generally know what is Actus Reus. It is a guilty act, but this guilty act, it refers to the external or physical element of crime. Okay, that means you have to note this. It is the part of the offense that can be seen or proved by the evidence. Okay, first of all, Actus Reus is a Latin phrase, meaning is a guilty act, and it refers to the external or physical element. That means it can be seen or proved by the evidence. So, a person cannot usually be punished merely for having bad thoughts. The law punishes conduct. Okay, now first of all, Actus Reus means what the accused did, or failed to do when there was a legal duty. That means omission. Okay, now here in this we are going to cover four elements, that is a positive act or voluntary act, next omission, next consequence, and next causation. This I will be covering in this video in detail. With this you will be having conceptual clarity. Now, generally bad thoughts are not punishable. Okay, why? Why having bad thoughts are not punishable? For example, if A sits at home and thinks of killing B, okay, he thinks, I want to kill B someday, even though the thought is morally wrong, but no crime has been occurred. So because of this, there is no actus reus, so the crime has not been committed. For merely having bad thoughts, A will not be held criminally liable. I will be explaining with another example. For an example, A buys a knife and goes to B's house and kills B. Okay. Now here actus reus is stabbing. Okay, stabbing to B. Now mens rea is also involved because he has the intention to kill B, because previously he sat in home and thought of killing B. So here actus reus and also mens rea has been proved. So therefore criminal liability generally begins only when a guilty mind is accompanied with guilty act, criminal liability. Now, if there's a bad thought, only bad thought only, then there is no actus reus in the first example, and there is no crime involved. Henceforth, there is no criminal liability. Okay. Next, if there's a bad thought accompanied with criminal act, that means here bad thought mens rea is present and actus reus is also present, criminal act, and because of this, criminal liability arises. So the common way to remember this is the law punishes only actions, not imaginations. This is the common way to remember. And next, in the further part of the video, we will be covering about the four elements of actus reus. I hope this slide is clear. Now coming to the elements of actus reus. Firstly, there are four elements of actus reus, and out of which first one is voluntary act, and second one is omission, and third one is causation, and fourth one is consequence or result. Different books refer different terms, but the concept remains the same. So, elements of actus reus. First one, we are going to talk about voluntary act. The act must be voluntary. Yes, we know this. And if the movement is involuntary, what happens? If the movement is involuntary, criminal liability does not arise. Simple. And for example, see, if someone punches someone intentionally, then criminal liability arises because it is a voluntary act. And driving a car negligently, it is also a voluntary act. Then these two arises elements of actus reus. Now, what are the acts which are not voluntary? Reflex movements of a person and convulsion. See, convulsion means nothing but a sudden violent movement of the body that you cannot control. Movement of a body that you cannot control. And sleepwalking. And for example, if a driver suddenly suffers an unforeseen heart attack and loses control of the vehicle, the act may not be voluntary. So, the elements of actus reus is in this slide we learned about the act must be voluntary, and if the movement is involuntary, criminal liability doesn't arise. And two examples of voluntary act are punching someone intentionally and driving a car negligently. And with the actions which are not voluntary are reflex movements and convulsion. And convulsion is something that a sudden violent movement of the body that you cannot control. And third one is sleepwalking. So these are the acts which are not voluntary. And for example, I gave this example: if a driver suddenly suffers an unforeseen heart attack and loses control of the vehicle, then the act may not be voluntary. Now the second element is omission. Sometimes dash can also amount to actus reus. Firstly, omission is also known as failure to act. Failure to act. Sometimes failure to act can also amount to actus reus, but only where there is a legal duty to act. And from where this legal duty arises? This legal duty arises from law, relationship, responsibility, and creation of danger. Okay, it sounds like all are similar, but I will be explaining with an example so it will be easy for you to understand in a rational way. First is also known as duty because it is mentioned in the statutes. So, what is the cause for you to stop at red light in a traffic signal? So the second thing is contract, the contractual duty of, for an example, a lifeguard as a contractual duty to save someone drowning in their zone. So example is lifeguard example. Legal duty is to save from drowning. Next, relationship. The special relationships. Parents have a legal duty to protect and provide for their minor children. Okay? Now, assumption of responsibility. Firstly, a person voluntarily takes responsibility of another person. That means if a neighbor, suppose for an example, an elderly woman lives after my house, and my responsibility is to look after her because their family members left for a vacation. So I said to their family members that I will be looking after her because by bringing her food and also giving her medicine. So if I don't look after her and if she falls sick, then I will be held criminally liable. Criminally liable in this element, omission element, because I failed to act. So assumption of responsibility is, I think, this is clear. Assumption of responsibility and creation of danger. Creation of danger means, for an example, if you accidentally start a fire and you have a legal duty to take reasonable steps to put it out or call for help emergency once you have become aware of it. So this is a creation of danger, and if you are not doing those things and not following those precautionary measures after creating the danger as well, then you will be coming under omission. That means failure to act. So these are the simple examples I gave. Example 1, parents intentionally fail to feed their children, that is relationship. And next thing is lifeguard example. Their omission may amount to criminal liability, that is contractual duty. I hope omission is also clear. Now the next thing is consequence. The third element we are going to deal with consequence. Firstly, not every crime is complete merely because an act was done. The law generally requires a specific prohibited act, prohibited result, and that is consequence. Okay, a specific prohibited result, that is consequence. So here certain offenses require a prohibited consequence, and examples are, firstly, the example I have taken here is murder. Act is stabbing and the consequence is death. Without death, it may amount to attempt or not murder. See, firstly, if a person physical act is stabbing and he also has the intention to kill, so the consequences arisen is murder. Until here it is clear. But if at all, here the consequences is different. If at all the consequences is not the death of the victim, then it will be amounting to attempt or hurt, but not murder. So here generally we need to talk about three offenses. Let us take four offenses: murder and causing grievous hurt, and next is attempt to murder, and next is let us take the other example, criminal conspiracy. Okay, until here it is clear. Now the first thing is, for this murder offense, let us ask a question: is consequence required? Yes, for murder, consequence offense is required. And what is that consequences? Required consequences: death of a victim. Okay. Now causing grievous hurt. Is consequence required for causing grievous hurt? Yes. and that should be matched with the pattern of BNS or IPC, and the consequence required is grievous hurt. Okay. Next, attempt to murder. Is consequence required for attempt to murder? No, because death of the victim is not possible here, and here the required consequence is the attempt is also punishable. Next, criminal conspiracy. Is consequence required for criminal conspiracy? Generally, no. And what is the required consequence here? Agreement itself constitutes the offense. Constitutes offense, and it is subject to the statutory conditions. So here generally, this is the table. First, these are the four offenses I took for generalizing the rational approach of is consequence required for this offense, and if at all if it is required, and what are the required consequences. I hope it is clear. But now I just wanted to uh, not complete the consequence slide with this thing. I just wanted to add one small flow chart so that it you can understand better. First of all, we need to take an example. There is an act. Okay. First, for an act, we should ask: is there any particular consequence for this act? Particular consequence, there or not? And if yes, what is the particular consequence? Did that consequence occur? Yes or no? If yes, then it will be constituting the offense. If no, another offense or attempt. That's it. First, you must take whether there is an act. If at all there is an act, whether there is a particular consequences for that act. If yes, did that consequence occur? That means for a murder, did the death of victim occur? And if the death of victim occur, then it will constitute offense of murder. Otherwise, it will constitute offense of attempt or another cause of offense. This is the general slide of consequence. Whatever the questions will be coming for the exam, irrespective of judiciary or any other exam, the questions will be asked from this slide itself. It will not go beyond this slide. The conceptual clarity will be clear after you thoroughly understand this slide. And next, I will be going to deal with element number 4, that is, I forgot to mention one trick for remembering consequence in a simple way. See, if there is no required consequence, if there is no required consequence, then there is no complete result crime. This is the simple thing which we have to remember for the consequence. And the next thing is, we are going to learn about causation. The fourth element of Actus Reus is causation. Okay. Now, firstly, not every crime is complete merely because an act was done. This we have discussed in the consequence part. Now, in the causation part, because people confuse between consequence and also causation, I will be clearing the differences between these two. Now, even if the accused committed a wrongful act, then the prosecution must prove that the accused act actually caused the prohibited result. It actually caused the prohibited result. So, For example, offenses like murder, prosecution must prove A committed the act. Okay, which act? Example, let us take stabbing. The act caused victim death. This act caused victim's death. Okay. Next, if the act does not cause victim death, then he may also be liable for another offense. That means in the previous slide we have referred for attempt of murder or causing grievous hurt. So until here it is clear. So basically causation has two parts. Here it is factual cause and the next thing is legal cause. Factual cause or legal. Okay. In the factual cause, we have to ask ourselves, did the act actually cause the prohibited result? Did the act of stabbing, did the act actually cause the result? Okay, until here it is clear. Now, in the legal way, in the legal causation, we have to ask, should the law hold the accused liable for that result? For this result, should the law hold liable for this result? So for both the parts of causation, factual causation, we have to ask, did the act actually cause the result? And the next, for the legal causation, means for satisfying this, we have to ask these questions. Should the law hold liable for this result? Accused. Okay. Now coming to factual cause, that is factual causation. The main determining factor for factual causation is but for test. For criminal law, in criminal law, it is very complicated. I will explain it in a simple way. See, for but for test, firstly, uh, we have to ask, but for the accused act, would the prohibited result have occurred? So, we have to ask in a simple way, would the result have happened but for the accused act? We will not be understanding this complicated language. I will be explaining in the simple language. So, if no, the accused caused it itself. So, we have to ask, see, firstly, you have to remember one simple trick. The trick is here, first we have to remove the accused act. After removing the accused act, we have to ask, would the result still happen? This is the question we have to ask ourselves. First, removing the accused act, and after that, would the result still happen? And if the answer is no, then factual causation exists. Yes. If the answer is yes, there is no factual causation. I think it is clear. I will be explaining this with an example. Firstly, A shoots B. Okay. Now this B dies from the gunshot wound. Now ask, what will you ask? Remove this, remove the accused act and ask, would the result, would the B die still? If the answer is yes, no factual causation. But the answer will be no, because B will not die. He died because of the gunshot wound which was done by the A. So if the answer is no, then factual causation exists. Now I will be explaining with the simple example. Another example: A lightly pushes B. Okay. Few minutes later, this B dies because a tree suddenly falls on him. Okay, tree falls on him. Now we have to ask, but for A's push, would B still have died from the falling tree? The answer will be yes. And if answer is yes, no factual causation exists. Now with the trick apply here, A lightly pushes B. Now I will be removing accused act. B dies from because tree fell on him. The answer will be yes, and no factual causation exists. So remember this trick for factual causation. It will be helpful for you in the future days as well. Now the next thing is and the legal causation. So for explaining in an easy way, even if A is the factual cause, that means in the previous slide I gave an example that A stabs B, and if at all if I ask that trick question, if I remove this accused act and ask that whether the prohibited result would have been occurred or not, yes. If the answer is no, then factual causation exists. So even if A is factual cause, the court asks another question, that is, if A's act sufficiently connected to the death of the victim, or as some new event broken the chain of causation. This is the main important theme of legal causation. So even if the A is the factual cause, the court asks another question, that is, as some new event broken the chain of cause. For an example, A's act. Okay, because of A's act, victim has injured. Now, victim has been admitted in the hospital. In hospital, victim has died. This is the chain of acts, chain of causation. Now, if nothing unusual happens, then the chain remains intact. Then A will be liable. Until here, it is clear. But when this chain, when this chain is broken, then what happens? This is the question. Okay, how does the chain break? When new or when new or independent event, okay, called as a Latin term. Make note of this thing. Novus actus intervenis, or for simple meaning, this means that intervening act. Okay, how does this chain break? When a new or independent event, that is an intervening act, because of this the real outcome of the result changes. For an example, firstly, A punches B. Okay. Now this B is taken to the hospital. Okay. On the way, lightning strikes. B, hospital. Here lightning strikes. Okay. And B dies on this way in the ambulance. Now, first, court takes two steps for the causation element, factual cause, and it asks one question. But for A punching B, would B have been in the ambulance? If if B is not punched by A, then B would have been somewhere, not in the ambulance. So factual cause exists, and after factual cause exists, again it goes to stage 2, that is legal cause. Now again it asks what actually caused the death of the bee. Lightning. Okay. While traveling to the hospital, during that, lightning strikes and bee dies. Because of lightning, bee actually died. And lightning is independent, unforeseeable, because no one can expect, and completely unrelated to the A's assault to B. Therefore, chain of causation breaks. So, A will be liable only for the assault of B, but not for the B's death. I hope it is clear. And I think you will be confused between factual cause or legal cause. The firstly, factual cause. Okay. And next is legal cause. Hmm. First, in the factual cause, we have to use the determining factor test called but for test, or my trick, remove the accused act, then you can easily get the answer. And for the legal cause, we have to look at where or whether the chain of causation is intact or not. Here the chain is broken by lightning strike, but here the chain of causation is not broken in the previous example. So, and the next element is chain of causation. Okay, these are the first primary prominent points for the determination of factual causation and legal causation. And the next point, important point, is for the factual causation, did the act actually contribute the result or not? A stabs B and B died. Did the actual act cause the B's death or not? If the answer is yes, then factual causation exists. So, did the act actually contribute result? Simple. The next thing is legal causation. In this, we have to ask, is it legally appropriate to hold accused responsible for the act? We have to check legal appropriateness. That's it for the act. These are the basic things we have to know for the causation part. And finally, it is the fourth element of the Actus Reus. Now, something is not filling apart. I'll be explaining with the flowchart as well. See, firstly, there is a causation. Okay, causation has two things. That is, two parts: factual and legal. Okay. Now, in the factual, we have to check for but for test. but for test. This is the determining factor for factual causation. In the legal causation, we have to check for was the chain broken or not, or is there any intervening act. This is the determining factor for the legal causation. And if the chain is not broken, no, liability continues. If the answer is yes, if the chain is broken, then liability for result ends. Now, for the factual causation, if the answer is no, then factual causation exists. If the answer is yes, doesn't. These are the tricks you have to remember, and for the concept clarity, you have to see the detailed video. I think the elements, what is Actus Reus, and what are the elements of Actus Reus, and the detailed explanation of those four elements, and with the basic examples. I hope uh, you are clear with all these things. Thank you. Wishing you all the best for your future exams.